Before discussing the controversial subject of abortion, a brief discussion of the right to privacy is warranted. The question is often asked, where is the right to privacy in the Constitution? Although the word privacy does not appear in the text or in the amendments, the United States Supreme Court has, beginning in 1886, enunciated a right to privacy in a series of decisions. The culmination of this series is the 1965 case of Griswold versus Connecticut, where the Supreme Court considered a Connecticut statute prohibiting the use of contraceptive devices and the giving of medical advice about them to married persons. Overturning the statute, the court specifically defined a constitutional right to privacy, which they argued could be found in a combination of the Third, Fourth, and Fifth Amendments, as well as the Ninth Amendment, which says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This argument was reinforced in the 1972 case of Eisenstadt versus Baird, which applied the Griswold decision to unmarried persons. This was the privacy case which most immediately preceded the court's decision in Roe v. Wade, and the two cases, Griswold and Eisenstadt, laid the constitutional framework for the majority opinion in Roe. While the lectures that follow begin with Roe, it should be noted that the Supreme Court's constitutional argument in support of abortion rights has shifted away from the Ninth Amendment and privacy. Since Planned Parenthood versus Casey in 1992, the court's constitutional foundation for the right to an abortion has been in the liberty protected by the Due Process Clause of the 14th Amendment. Well, good afternoon, everybody, and of course, welcome back to PLS 103, Missouri Government and Politics. We have been spending a lot of time, maybe an inordinate amount of time, on the institutions of politics that exist here in the state of Missouri. Today, I want to talk about, or begin talking about, the intersection of those institutions. And if you think about it this way, we've got what we just finished, the judicial line. And then we have an executive line, and then, of course, we have a legislative line. And what I want to focus on today, next time, are the implications or the politics of the intersections of the judicial branch, the executive branch, and the legislative branch. And I really want to talk about the executive branch here in terms of those separately elected office holders. We're going to come back to that and focus on the Attorney General, and we're going to zero in on the court system. But ultimately, what the court system is going to be deciding on legislation passed by the state. I want to talk about a controversial subject, and that is the right to an abortion. Now, it used to be, when I asked, what was the first court case that you learned as a child? Most students would say Marbury versus Madison, 1803. That's not true today. Most students, if I say 1973, they say, Jim, thank you very much. I say 1973, you say Roe versus Wade. Regardless of your opinion of this court's decision, everybody knows it. And the impact of Roe versus Wade has, of course, been felt nationwide. I want to focus on the impact of Roe versus Wade and that abortion decision here in Missouri. And we are going to talk about the intersection of the legislative reaction to Roe versus Wade, the executive reaction, the judicial reaction, popular reaction with respect to the people of Missouri, and how that has had an impact on national politics as well. So let's just start with a very brief review of Roe versus Wade. 1973, the Supreme Court establishes the right to an abortion under the constitutional protection of a right to privacy that is found primarily in the Ninth Amendment. Now, this right to privacy in the Ninth Amendment is probably the most controversial aspect of the decision. But that's the American government class. I'm going to focus on the Missouri government, and we'll come back to this later on, not this class period, but certainly the next class period. The core or the heart of Roe versus Wade is what's known as the trimester formula. And as the name suggests, the trimesters divide pregnancy into 3 parts, or 3 trimesters. And the Roe versus Wade decision permits abortion at all 3 stages of pregnancy. The question is, in Roe versus Wade, who gets to decide? And then on what grounds or in whose interest is that decision made? So Roe versus Wade establishes the trimester formula. First trimester, first 3 months, roughly, the woman or the mother is the person who decides to or not to have an abortion on her own. In the second trimester, the decision is primarily the woman's or the mother's, but the Supreme Court allows the state to have a role in that abortion decision. But it's important that the state's role is with respect to the life of the mother, not the unborn child. Third trimester, I don't really want to reverse it, but the state has a more paramount role. And in this case, the state has a role with respect to abortion and the viability of the child. The trimester formula is based on viability, whether the unborn fetus can survive outside the womb. So in the third trimester, the argument is the fetus is viable and the state has an interest in protecting the life of that child. So that's the overview of 1973 Roe versus Wade. Establishes the right to abortion under the 9th Amendment, right to privacy. Okay, now let's go back. What color is Missouri? Carly? Missouri is a red state. Thank you for remembering. Missouri is a red state, which means Missouri is a conservative state. So Carol, how does Missouri react 1973 Roe versus Wade? No, Missouri as a state, not individuals. Missouri is a red state, is a conservative state. How does the state of Missouri react to the abortion decision? Missouri as a state is not in favor of Roe versus Wade. Missouri is a conservative state. And it reacts negatively to Roe versus Wade. And what I want to spend the first part of this Missouri's response, maybe this side of the board versus that side of the board, is how Missouri responds early to the Roe versus Wade decision. Now, Missouri is a conservative state, but I want you to remember something important. For all of the court cases I'm about to discuss, for all of the laws that are passed and challenged, Missouri has a democratically controlled legislature. So it's important to remember, maybe it's hard to remember today, what separates Democrats and Republicans. But because Missouri is a conservative state, Missouri has conservative Democrats, and it's a democratically controlled legislature that's in charge of the state during this first period in response to Roe versus Wade. The first legal challenge from Missouri, first legal challenge, is Planned Parenthood versus Danforth in 1976. This is the first challenge to Roe versus Wade from the state of Missouri. And I'll draw, for lack of a better thing to do, what Missouri is trying to do is take the Roe versus Wade decision and narrow its application. Take the Roe versus Wade decision and narrow its application. In Planned Parenthood versus Danforth, this gets all the way to the United States Supreme Court, and the United States Supreme Court rejects spousal and parental consent. United States Supreme Court rejects spousal and parental consent. The legislature had passed the statute not getting at the heart of whether you could or could not have an abortion, but if you were to have an abortion, you would need spousal or parental consent. Again, Missouri's attempt to narrow Roe v. Wade. The Supreme Court rejects that first attempt to narrow abortion rights in the state of Missouri. But that's just the first try. Planned Parenthood versus Ashcroft, 1983. The second attempt that made it to the United States Supreme Court is the case of Planned Parenthood versus Ashcroft. This is a two-parter. Number one, once again, the Supreme Court rejects second trimester hospitalization. If there is an abortion in the second trimester, the statute passed by the legislature said it had to take place in a hospital. Supreme Court rejects second trimester hospitalization. But, and this is significant, rejects the hospitalization requirement, but accepts a requirement for a second physician to be present during an abortion and minor consent. Now, second physician is obvious, it means two physicians, but the minor consent needs a little bit of explanation. If a minor is seeking an abortion in Missouri, they must get permission. Now, the argument is, well, what if your parents don't give you permission? Does that mean you could not get an abortion under that statute? And the answer was no. The law provided if you could not get parental consent, you could get judicial consent. So if the parents refused to grant consent, a young woman could go to the judge and get judicial permission. And so Missouri as a state is trying to narrow abortion rights. First case, the court says no, can't do that. Second case, Planned Parenthood versus Ashcroft, Supreme Court says no, you can't require second trimester hospitalization, but you can require permission for minors and you can require a second physician to be present. So Missouri statute tries to restrict abortion, goes through the court system, the U.S. Supreme Court says, yes, you can make those restrictions. The watershed case, if we're talking about restricting abortion rights in Missouri, is Webster versus Reproductive Health, 1989. So let me get back to that one. I'm sorry, Paul? Okay, Danforth, Ashcroft, Webster. They are the attorney generals of the state of Missouri. When we talked about the attorney general's role is to represent the state of Missouri when it is challenged in court, especially when it's challenged at the United States Supreme Court. So these court cases are challenged in the enforcement of these statutes through the attorney general. And so that's why it's the name as opposed to the state of Missouri. But good question, thank you. All right, Webster versus Reproductive Health. Okay, another long one. What year did I say? So I don't have to look at my notes again? Thank you. 1989. I remembered, I was just seeing if you were paying attention. Webster versus Reproductive Health, 1989. This is a Missouri case that goes, again, all the way to the Supreme Court, and fundamentally it says this: it upholds the right of state legislatures to restrict abortions. Webster versus Reproductive Health, a Missouri case, number one, allows or upholds the right of the state legislature to restrict abortions. Now, this is an important principle, but it's just the beginning in this particular case. Webster versus Reproductive Health also upholds a ban in the state of Missouri on public employees, public facilities, and public funds to be used in abortion. No public employees, no public facilities, and no public money. So in Webster versus Reproductive Health, it doesn't say you can't get an abortion in the state of Missouri, but it does say that you're not guaranteed or allowed to have public employees, a public facility, or any public funds used for that. The most important aspect of Webster versus Reproductive Health is number 3. And it takes the principle of number 1, that states can restrict abortions, and says states can impose regulations on any stage of pregnancy. Now, Supreme Court of the United States is always very careful. It doesn't overreach or overstate. The states could impose regulations at any stage of pregnancy. That implicitly overturns the trimester formula that was established in Roe versus Wade. Implicitly overturns. Now, I say implicitly because they don't do so explicitly. That comes in a later case, Casey versus Reproductive Health in 1992. Casey versus Reproductive Health, 1992, throws out the trimester formula established in Roe versus Wade. It does so because of the precedent set here in Missouri. The Casey case was a Pennsylvania case, but Missouri sets the bar with Webster versus Reproductive Health. The Supreme Court implicitly discards the trimester formula here, only to formally discard it a few years later in 1992 in Casey. Now, I'm not writing Casey on the board. It's a Pennsylvania case. If this was Pennsylvania state politics, we'd put Casey versus Reproductive Health up there. So, in response to 1973 decision of Roe versus Wade, Missouri attempts to restrict abortion rights in the state of Missouri. At first, the Supreme Court is reluctant to permit these restrictions, but slowly and surely, the Supreme Court of the United States allows Missouri to increasingly restrict abortion rights in the state. Now, we're going to use this line right here to talk about some dramatic changes in the state of Missouri and also on the Supreme Court. I don't want to focus on the United States Supreme Court because this is Missouri politics, but we know that the United States Supreme Court changes. Members resign, members die, members are replaced, ideologies change, presidents change, the mood of the country changes, the Supreme Court changes. I want to focus on what happens in 2003. So if you could make this line 2003, or, yeah, we'll just do it this way. This line is 2003. What happens in 2003? The Republicans gain control of the General Assembly in Jefferson City. Okay, Missouri is a conservative state controlled by the Democratic Party. Missouri is a conservative state in 2003, now controlled by the Republican Party. So, Joni, more conservative or less conservative? Joni says more conservative, and Joni is right. The Republican Party in Missouri in the 2003 takeover represents a more conservative political agenda or ideology than even the most conservative of Democrats prior to 2003. So if Missouri tried to restrict abortion rights after 1973, are going to ramp up the restrictions starting in 2003 because of the Republican control of the legislature. But it's important to recognize that the Supreme Court of the United States is also becoming more conservative from 2003 forward. And so we're going to have a confluence of Missouri's increasing conservatism with the Supreme Court's increasing conservatism. Now, I don't want to say that all Republicans in the state of Missouri, all Republicans in the state legislature or state government are in lockstep on this particular issue. We did see tension within the Republican Party with respect to stem cell research. There was a split with an entrepreneurial wing of the Republican Party with the more pure right-to-life aspects of the Republican Party. So I don't want to paint with broad strokes, but there is a significant change in Missouri politics in 2003. And as you might imagine, I think as Joni was suggesting, the legislation that comes out of Jefferson City with respect to abortion tries to further restrict abortion rights in the state. Let us start with 2003. 2003, 24-hour waiting period. If a woman is seeking an abortion in the state of Missouri, according to the 2003 statute, she must wait for 24 hours and receive medical consultation as to the effects of an abortion. And then 24 hours later, can have the abortion. So in 2003, this is the first significant attempt to restrict abortion rights. It is vetoed by Governor Holden. Governor Holden's a Democrat. And that veto is overridden. That veto is overridden by the legislature in 2003. Governor Holden vetoes the waiting period. That veto is overridden by the legislature, and that veto override includes Republicans and Democrats. So some of those same conservative Democrats who were opposed to the 1973 Roe versus Wade side with the Republicans in the majority now in 2003. So overridden with the support of Republicans and Democrats. To take this one step further, this 24-hour waiting period goes to the Missouri State Supreme Court. Missouri State Supreme Court in reproductive health versus Nixon. I want to be sure I get the right one. This takes a while to get to the court. Reproductive health versus Nixon. Again, why Nixon, Paul? It was your question. It was because Attorney General Jay Nixon. Reproductive health, I'll just abbreviate now, we all know what it means, versus Nixon. And this is 2006, the Missouri State Supreme Court upholds the 24-hour waiting period. The legislature passes it, the governor vetoes it. The legislature overrides the veto. The same law is challenged at the Missouri State Supreme Court, and it is approved. So we have, again, the narrowing of abortion rights. Also, we take a step 2005. Going into the future just a little bit, in 2005, Missouri passed a law restricting what would be transportation with respect to abortion. Let me just read the statute. No person shall intentionally cause, aid, or assist a minor to obtain an abortion without consent of a parent. Parents and guardians can sue those who violate the law, seeking compensation for emotional injury and punitive damages. Now, the basis of this law, in a nutshell, was an attempt to prevent someone from taking a young girl in Missouri across the Mississippi River into Illinois in order to get an abortion. The argument here was to prevent transportation of a minor to get an abortion essentially out of state. Now, this, of course, like everything else here, is going to be challenged in court. It goes to the Missouri State Supreme Court. Again, Planned Parenthood versus Nixon. So how are we going to do this? You're going to have to remember these. In part, by the year, and in part by who's who. So what's the difference between, this is reproductive health, which is an offshoot of Planned Parenthood, but reproductive health versus Nixon 2006. This is Planned Parenthood versus Nixon 2007. But the ultimate end of this is the Missouri State Supreme Court upholds that law that allowed people to sue someone who transported a minor to receive an abortion without consent. All right, again, state of Missouri trying to narrow the availability of abortions. Now I'm going to erase because I don't have enough boards to do all this stuff. I have two other big moments here. 2010 and 2011. And I think it's important to talk about them as well for legal and political reasons. 2010, a major attempt by the legislature to narrow abortion rights. And this is almost a bullet point list. And so let me read to you and then we'll put it on the board. Before a woman could get an abortion in the state of Missouri under the 2010 statute passed by the legislature, they must first be asked if they want to hear the fetus's heartbeat. That's number one. Number two, be asked if they want to see an ultrasound of the unborn child. Third, be told that the fetus feels pain and they will be offered anesthesia for the fetus. I guess we could make that fetal pain. They will also receive a pamphlet with the words, "The life of each human being begins at conception. Abortion will terminate the life of a separate, unique, living human being." And all clinics were required to display this sign. There are public and private agencies willing and able to help you carry your child to term and to assist you and your child after your child is born, whether you choose to keep your child or place him or her for adoption. The state of Missouri encourages you to contact those agencies before making a final decision about abortion. So, pamphlet and signage requirements. And the 2010 law also modified the 24-hour waiting period. The courts interpreted the original 24-hour waiting period to allow for a medical consultation by phone. So it enforced a 24-hour waiting period, but you could have that medical consultation about the effects of an abortion by phone. The 2010 law requires that waiting period, that the consultation be done in person. So a woman seeking an abortion in the state of Missouri has to have these four elements, and they also must meet in person with a medical professional to discuss the side effects of the medical side effects of an abortion. So this statute passed in 2010, fairly significant attempt by the legislature to narrow the range of abortion rights in the state of Missouri. Is that a question? Okay, well, let's jump ahead now to 2011. And I want to come back and talk about one thing with respect to 2010 in just a second, but let's go to 2011. The legislature in 2011 passed what was called the late-term abortion ban. This is often referred to as partial birth abortion. In 2011, the legislature in Missouri enacted a ban on late-term abortions. And again, this is a bit of a refinement of an earlier statute, so let me read it to you. Missouri law had prohibited late-term abortions unless necessary to preserve the life or health of the mother. Preserve the life or health of the mother. The 2011 law, the law passed in 2011, narrowed the general health exception to cases to save the life or prevent permanent physical harm of the mother. So what was a general health exception to late-term abortions became life of the mother or permanent physical harm. Again, the right to an abortion is intact, but the availability of that right is narrowed under this 2011 statute. Now, I'm going to give you an asterisk. It's a double asterisk. Both the 2010 and 2011 statute were passed during the term of Governor Jay Nixon. Now, Governor Jay Nixon is a Democrat, and we talked about governors signing and veto and line item veto and so on, but one of the options available to the governor is to not sign at all. And as we said earlier, when a governor does not sign a bill, it becomes law by default. And both of these statutes in 2010 and 2011 became law without the governor's veto, without the governor's signature. Again, the issue of what kind of Democrats do we have in Missouri? And the answer is, as we talked about before, even going back to the 1973 era, there's a significant conservative vein that runs through the Democratic Party in the state of Missouri. So there may be some political implications for a governor running for re-election here to veto the bill, to make some people upset, to sign the bill, to make some other people upset, but ultimately the governor allows both of these bills in 2010 and 2011 to become law, and so Missouri again restricts the availability of abortions. Now, I can take this even into the future. It'll just be 2 years from now. But the statute in 2011 also affects 2014. So even though it's 2 years away, I can tell you what the statute in Missouri is going to look like. Now, as you know, the health care reform debate in Washington, D.C. is quite contentious. And that debate has trickled down into the states. But the statute in 2011 dictated what's going to happen if and when the health care plan passed by the legislature and President Obama, if that becomes law in 2014 or becomes law in the way in which it was passed, the federal government will mandate what's called state exchanges for insurance. The health care bill mandates state exchanges for insurance as a way to lower costs. In 2011, the Missouri legislature looked into the future at those state exchanges and said, whatever shape or form they take, no state money will be used, or the monies used by those state exchanges is prohibited from being used for abortions. I think abortions are prohibited from, say it differently, abortions are prohibited from being covered by these state insurance exchanges. So let me say it this way. Abortion coverage is prohibited. So even into the future, next time we reshoot these lectures, we'll be looking at 2014 in the past. Right now it's 2 years out. We don't know the shape of the national health care reform because it's still in the future. But If the state exchanges come to be as they were designed, and we have access to that in Missouri, none of that coverage can be used for abortion. So, it's politics. Democrats, conservative. Republicans, conservative. Missouri, conservative. Reacting to 1973 Roe versus Wade, Missouri continually tries to attempt to narrow those rights. Less successful at the beginning, but a significant change in 2003 with an increasingly Republican Supreme Court, with an increasingly Republican conservative legislature and an increasingly conservative United States Supreme Court. But at the end of the day, it is Missouri as a state, whether you support abortion rights, pro-life, pro-choice, it is Missouri that is in many ways driving the national debate. It's as these statutes get challenged and go all the way to the Supreme Court, as these statutes are challenged and go to the Supreme Court, Missouri is setting the stage for abortion politics in the United States. Question, Joni? All right. Next time, I'm going to talk about another aspect of the right to privacy in the Ninth Amendment, and that's going to be the discussion of the right to die. Some of the same statutes, some of the same characters, some of the same attorneys general are going to be involved, but it's a very different result, and I think you'll find it interesting. All right, thanks very much.